Hello guys, and welcome to my lecture. On today's lecture, we'll be talking about the fourth exception of the indoor management rule. And fourth exception discusses cases involving insiders. A director or purported director or someone so closely related to the company as to have been taken to know of the internal irregularity won't be allowed to rely on the indoor management rule. Now, when we look at the case of Howard versus patent manufacturers, the debentures had been issued for amount under which articles require authorization by resolution of the general meetings. No resolution has been passed, and some directors of the company also received issued debentures. For the directors, the court held that debenture holders were not allowed to rely on the rule because they must have known of the internal irregularities. That means that they must have known that no regulation had passed. When you are part of the internal management of the company, the rule will not avail you because you ought to have known that something is wrong. You ought to have known that the right thing has not been done. In the case of Howard versus patent manufacturers, the directors were issued debentures, but for debentures to be issued according to the articles, then there must be a resolution. The resolution there forms the non-ostensible conduct. Do not forget that the non-ostensible conduct, according to third parties, they can presume that the non-ostensible conduct has been done, therefore presuming regularity. But this presumption will not be in favor of insiders because they ought to know that the non-ostensible conduct has not been done. Do you understand? We go to the case of Morris versus KANSESEN, where C, whose appointment as director has ceased, S, who has never been appointed director, purported to hold a board meeting and appoint M a director. All three purported to allot shares to M, sought to rely on the rule to validate the appointment and allotment of shares. The court in this case held that the rule would not apply since M purported to act as the director in the transaction. Lord Simmons, I love what Lord Simmons said, and I want us to pay very important attention. Lord Simmons stated that it is a rule designed for the protection of those who are entitled to assume, just because they cannot know that the person with whom they deal has the authority which he claims. It is the duty of directors as well as those who purport to act as directors to look after the affairs of the company, to see that it acts within its powers and that its transactions are regular and orderly. To admit in their favor a presumption is rightly done, which they have themselves wrongly done, is to encourage ignorance and condone dereliction from duty. So if we look at this case, the basis of this principle is on good faith. Because here we are saying that there is no way the third party can look into the internalities of a company, that is the internal management of a company. But the directors, it is their job. It's just like shareholders as well. The shareholder, let's say a shareholder wants to get a particular share, and then the shareholders knows that there are certain things that should have been done before he gets the shares, and he still got it either ways when those things have not been done, and then he's shouting presumption of regularity. Who is the company? Are you not part of the company? So why are you shouting presumption of regularity where you are supposed to have known and you are supposed to have rightly done what it is to be done? Do you understand? So that is that for the fourth exception. And then we go to the last exception on the indoor management rule. See you in next class.